Today we're going to address 20 commonly asked questions about 485J supplement in AC21. That is the one that you use to change the jobs when you are in adjustment of status of 485 application. Now, along with me is my business partner, Ryan. My name is Rahul Reddy. Ryan, when can you change the jobs after filing the 485 application?
So once you've filed your 485, so you've got your 485 receipt notice in hand, 6 months after that receipt notice date, 180 days, you are entitled to file the 485 Supplement J to port or change your employer from company A, who supported you on the 485, to now this company B or maybe company C, who you're going to continue your green card process with. And so Rahul, a lot of questions, the first question we often get is, my I-140 isn't approved, maybe I did a downgrade back in October 2020. It's been 180 days, of course, since you filed your adjustment of status. Can you now file a 485J and change employers?
Technically, Ryan, you can change it while the I-140 is pending, though. However, we strongly recommend people not to do it because if you do change the employer before the I-140 is approved, Ryan, the company can withdraw the I-140. There may be an RFE on the I-140. The court ruling says that employee has a right to interfere into the I-140. It should be approvable at the time of filing the application. However, though, the way the USCIS will do it, it will deny the application and then we have to go to the court to get it. That is a proper procedure. And that's a lot of tension for the people. I would advise people under all conditions, do not change the jobs until the I-140 is approved. And if you're planning to do it under some emergency circumstances, please consult a lawyer before you change the job when the I-140 is pending. Now, Ren, is it necessary that they have to wait for 180 days after the I-140 is approved, or is it only from the time of filing the 485 application?
Generally, the time of filing the 485 application. Like Rahul said, you would probably prefer to have the I-140 approved, but strictly 180 days after you filed the 485.
There is no rule that says that you have to wait for 180 days after the I-140 is approved for the purpose of the AC21, for the purpose of the 485J supplement. You do not have to wait for 180 days. Is it recommended to go with the same lawyer that filed the 485 application to change the 485J, or is it recommended to go with the company B's employer, or can you choose your own lawyer though?
I would likely advise to change your lawyers from maybe if company A filed your 485 and you had an attorney who you used for that I-140 and that 485. I would advise to change attorneys. There's a number of reasons. Generally, it's going to be company A's attorneys are tied to company A. They might not be allowed to, so to speak, to help you with the 485. It's not required that you change the attorneys by any means. It is advisable.
My employer said that he's going to withdraw the I-140 for all the employees who leave the company. Is that going to affect the 485J process?
No, it shouldn't.
The new job is not exactly matching my current job. Is that going to be a problem?
That shouldn't be at all. The term of art that USCIS uses is same or similar job opportunities. So if you're within the computer science, generally the engineering or technology realm, you're going to be fine. They don't want to see you going from being a computer science engineer to a chef.
This question comes out very frequently. I don't know where people are reading the news. They're very paranoid about changing the position. Oh, I'm moving from Java to SAP. Still, it's a damn software, guys. It's not a problem. We have had experience from the time AC21 law came in, somewhere in 2002. I was a lawyer even before that, doing the 485 application, when they're not allowed to change the jobs before they get the green card. But from 2002 onwards, it's been allowed to. There is only one denial that I've noticed when the people have changed the job and the USCIS is not satisfied. The guy was moved from a software profession to a restaurant manager. And no, the justification did not work, it failed. Every other 485J supplement, every other AC21 that has been filed had no problem in approving, even if the job duties are different. As long as they're in the similar occupation, I didn't see any problem. Now, Ren, sometimes I've seen the USCIS issuing the 485J supplement receipt notice when we file the 485 application though, because we include the 485J supplement if the I-140 is already approved. Sometimes they don't. But when you do the portability to change the new job, do they issue a 485J supplement?
They should be. And with all things USCIS, if you don't get it, don't let that be an alarm. But generally, you should expect a receipt notice for the 485J when you're doing the portability.
My new employer says that he's going to only issue the 485J supplement if there's an RFE or at the time that interviews. Is it okay to join?
It's okay, but I would make sure that that new employer, you can pin him down or her down and get that 485J if the RFE comes.
Yeah, it's not mandatory that you file the 485 before you join the company. You can file it at a later time. We normally strongly recommend people to file the 485J supplement, but we have seen people where having filed the 485J, when the RFE comes in, when they go for the interview, that's perfectly okay, because I see a lot of bigger companies, they're not offering the 485J supplement unless there is an RFE. But make sure that, as Rayan has pointed out, that they have the commitment that they are going to issue the 485J supplement at a later date, because once the RFE comes in, you're with that company and they don't want to issue 485J, then you may be in trouble. Once the interview comes in, you have to take, if you're not working for the same company, you have to take the 485J supplement. You will not have enough time to get another sponsor at that point of time.
All right, Rahul. A moment ago, you asked me, does the job opportunity, does the job title, the duties, do they have to be the same? What about the salary? Does the salary have to stay the same?
No, salary doesn't have to be the same. Okay. It can vary. It can be, and people ask me the question, can it be lower than the current salary? The answer is yes.
Okay, so we've talked about duties can change, salaries can change. What about geographic location? Say my perm was done in New Jersey. Can I take a job in California?
Absolutely not a problem.
Not a problem.
Not a problem.
Okay.
It can be a different geographical location and not a problem for the 485J supplement or AC21. Okay. And why is it 485J or is it AC21?
They're the same thing. Before this form, the Supplement J was created, the idea was given to us by this law AC21. Sometime after the passage of that law, USCIS got their act together, gave us an actual form that we could use to submit for these requests. And so when we say AC21, when we say 485J, they're the same thing.
Does the new employer has to show the ability to pay in the 485J supplement?
So within any green card case, there is this idea of ability to pay. When you're submitting the 485J, you don't need to demonstrate then and there that the company has the ability to pay. But you do need to make sure that that company has the ability to pay. And what does that mean, in essence? That they can either pay your wage, that they have the tax returns to cover whatever the wages that they would be offering to you. Generally, you shouldn't have a problem with ability to pay when you're looking at the 485 Supplement J.
Does my priority date has to be current in either filing dates or final action dates for me to file the 485J supplement?
No, once you've got the 485 pending, once USCIS has accepted your 485, you can put forward a 485J at any time, after 6 months of pending, of course.
If my EAD extension is pending and it is not approved, can I still file the 485J supplement? And when I file the 485J supplement, since the previous EAD has been filed with the previous company, do I need to file one more EAD extension?
No, you shouldn't. So another EAD question is, my EAD right now, it hasn't been approved. I have my pending 485J. We were talking a moment ago about, you have a pending EAD. Now your EAD hasn't been approved. Can you change employers? How do you go about that?
If the initial EAD has not been approved, though, it's pending though. If the I-140 is approved and 485 has been pending for more than 180 days, you can change the job. But the only thing is that you still need to file a H-1B with a new company though. Because since you don't have an EAD to work with the company B, then you have to file this H-1B transfer that will allow you to work with company B, but it is not mandatory that EAD has to be approved. A lot of people ask this question with regards to the EB1C, job portability. The people who have filed I-485 under EB1C, can they port after the 6 months? Yes, they can port the job after 6 months after the I-140 is approved and 485 has been pending for more than 180 days. But one condition is that make sure that I-140 is approved. Now, here is where a lot of people ask the question. For the EB1C, the person must have worked for the foreign entity for a period of 1 year before he came into United States company. Is that a requirement for the porting the job? The answer is no. Even though the new company does not have a foreign affiliate and you have not worked for the foreign affiliate, you can still go with the portability. Now, the requirements are that it must be the same level of position for which you got the EB1C approved. That's all. It doesn't. The company foreign affiliate requirement does not have to meet any requirement. Any more questions on the 485J supplement? 485J supplement can be filed by the new company's lawyer. You can use your independent lawyer also to do the 485J supplement. As Ryan has said, it's always advisable to change the current lawyer, because we do represent people who are filing 485 and they're moving from our company to another company. I just tell them, hey, we can't do it because we are in conflict with our company A. So it is probably recommended for you to change the lawyer. You don't have to necessarily go with the company B's lawyer also. You can have your own independent lawyer, or you can go with company's B lawyer. That's fine too. Any other things that we have missed?
One question I often get is, right now I'm in a pending green card state. Once my green card has actually been approved, how long do I have to stay with that company?
You don't have, once the green card is approved, Ryan, you can leave the company immediately though. Immediately. There is no reason, Ryan. There are a lot of rumors out there saying that you have to work for 180 days. No, there is nothing like that. Once your green card is approved, you can be flipping a burger, you can be a Microsoft CEO, you can be a lawyer like me, or you can sit down at home, do nothing. There's no requirement at all. Ryan, what if I have filed a 485 application with a company that I have never worked with? Okay, it's a future employment and it's more than 180 days. I-140 has already been approved. Can I switch? Can I have my current employer file a 485J supplement?
Of course, no problem at all.
So even though I never worked for the company, now the company that I'm working can file the 485J supplement.
The quick legal theory behind it is that the green card is all about that future job, that future employer that you're going to engage with once the green card's approved. So up until that point, what you're doing is convincing USCIS that that is your intent, that's who you're going to work for. Once things change, once you utilize the law, USCIS won't have any problem with you going to work for another company. The fact that you never may have worked for that first company to begin with. No problem at all.
A lot of people ask this question to me, Ryan, that, hey, when I never worked for the company, or when I leave the company within 180 days, I may get a problem in the citizenship. The answer is no, you will not get a problem in the citizenship. As Ryan has pointed out, the law is very clear. It is the offer of employment that is important. Whether or not you have been employed with the company is not the reason why you're getting the green card. It's the offer of the employment that is very important.
Oftentimes we've been in the H-1B mindset for so long that it warps our ideas on what the green card allows and what the green card universe looks like. So you do have to decouple what you think you know about H-1B with what we think we know about the green card side of things.
Another question. I've been with the company now for 180 days. I have filed a 485J supplement. Is it necessary that I have to stay with this company for 180 days before I move to company C?
No, there isn't.
There's no requirement that it's only the first company that you filed, the offer of employment has to be for 180 days. But if you're moving from company B to company C, there's absolutely no requirement that that you have to stick with the company B for 180 days. Now, if people have to change the job within 180 days after filing the 485J, within 180 days, it's definitely a risky thing. USCIS may question that whether or not you have the still job offer for a period of 180 days. It is definitely a risky thing if you're changing within 180 days for the first company. For the second company, there's no requirement.
One thing that, especially within the last few weeks, we've been asked about is porting, or not porting, but interfiling. So maybe with company A, I filed my I485
under
EB3, and now I want to convert that because I have already approved from that same company EB2. What is your opinion on putting forward a 485J? Maybe if you're doing an interfiling, would you want to do it before, after? What's your take on that?
It definitely has to be before though.
Okay.
The reason is that the I-140 belongs to company A, so it cannot be used after porting the 485J supplement.
So if you do the supplement J today, tomorrow you can't do the interfiling?
No, because the I-140 belongs to the previous employer. But but there is no requirement that after you do the interfiling that you have to wait for 180 days. There's absolutely no requirement. Yeah, if you're refiling the entire 485 application, and if you want to use the second 485, then at that point of time you have to wait for 180 days. But if you have interfiled with the EB2 and you want to change, there is no rule that says that you have to wait for 180 days. The rule is still the same, is that once you file the 485, you have to wait for 180 days before you move to the different company. Anything else, Ryan?
No, I don't think you have anything else to add, Rahul.
Thank you very much. But if you want to consult us or me, Ryan, or any of our office, you can follow the links there at the bottom and then have a private consultation if you need to speak with more. Thank you for tuning in.
Thank you.